Good morning and welcome to this WIOA Wednesday webinar. My name is Kirsten Sheary with the Illinois Center for Specialized Professional Support at Illinois State University, and I will be the moderator for today's webinar. Today's topic is navigating criminal records relief in Illinois. Just a couple of housekeeping things before we get started. As a reminder, all participants on the call are in listen-only mode. If you have questions as the webinar proceeds, please post your question in the text box that's provided on your side window panel. This box might be labeled a different name depending on where you're accessing your webinar today. So it might be labeled the question box, the comment box, or the chat box, but all of those boxes are synonymous and they allow you to ask us questions. So just depending on if you're on a tablet, phone, or computer, that box might be labeled differently, so just make note of that. Another reminder that this webinar will be recorded and the presentation recording and handouts presented today will be available on the icsps.illinoisstate.edu website as well as on the Illinois WorkNet website within 48 hours. Tomorrow, each attendee will receive a follow-up email, which will include a survey asking you about today's webinar. Please provide feedback and any suggestions you have to help improve upcoming webinars. Another reminder that if you find yourself having faulty internet connection or audio connection and you would prefer to call in, you can do so by calling into the webinar using your cell phone, and the phone number for that is placed in the chat box as well as it is on your original registration email that you received. And with that, we're going to get started with a couple of polls this morning just to get to know our attendees. So this is my introduction slide, Kirsten Sheary with ICSPS. And we have our presenter today, Cynthia Cornelius. So our first couple of polls is just the ones that we do every Wednesday to kind of get a gist of where our attendees are joining us from. So if you could answer where is your local area, I'm going to go ahead and launch the poll for everyone. And we'll give everyone about 30 seconds to answer this. Okay, I'm going to go ahead and close the poll. We do apologize for the limited amount of options. We're only allowed to type so many, but it looks like we have a good broad variety of percentages joining us from all over the state today and a couple from statewide as well, which is always great to see. I'm going to go ahead and launch the next poll, which kind of just gives us a gist of which partner you represent today. Again, the answers are limited, so if you would like to be more specific with us, you can type that in the question box. But we'll give everyone about 30 seconds to answer this poll as well. Which partner do you best represent? Okay, and with that, I'm going to close the poll and we'll share our results here. So it looks like we have 41% from Title I, 13% from Title II, 4% from Title III, and other WIOA partners, we have 30%. We did have a couple comments from people joining us from DHS, TANF, and corrections, which is great. So with that, I'm going to go ahead and close the poll. And we'll go back to our slides here. And with that, I'm going to hand it over to our presenter today, Cynthia Cornelius. Cynthia, if you want to take over.
Sure, but Kirsten, I am not seeing the slides. I just see WIO professional development showing up on my screen.
Thank you. I will fix that right now. There we go.
All right.
Is this your first slide?
That is the first slide. So good morning, everyone. Thank you for joining us today. It's my pleasure to be here with you this morning. Want to just start by letting you know a little bit more about Cabrini Green Legal Aid. We've been around since 1973. We started out as a ministry of LaSalle Street Church. We were at the time just serving the Cabrini Green community. That was a pretty large community in a small section of Chicago, about 15,000 residents in a square mile. But eventually, the ministry that was providing the legal services to the community broke off and created a legal aid. But again, we were focused on just the residents of Cabrini Green until we branched off a little further and expanded our services to the entire city of Chicago. We provide legal services in family law, housing law, criminal defense, and criminal records. And we also provide services for juvenile expungements. And so now we are supporting the entire state of Illinois with our criminal records services. We have traveled to Peoria, to Sangamon, to Winnebago, to Champaign, and Madison, and Macon, and Vermilion counties, working with Land of Lincoln and Prairie State Legal Services. So I see that we have quite a broad mixture of residents throughout the state here. So I hope that you will find this information very helpful, and just know that we'll be talking about where people can go to get services at the end of the presentation. So thank you. Kirsten, next slide. Now, Cabrini Green Legal Aid started off, again, serving the entire community of Cabrini Green Legal Aid in Chicago. And until 2014, we were basically accepting clients from the general public for, say, our housing law and our family law positions services. But in 2014, we decided to completely focus all of our services on people who are impacted by the criminal justice system. And that came about as we recognized the severity of the impact of having a criminal record on getting housing and employment. And so we began to focus all of our work on individuals who have had some sort of touch with the criminal justice system. So we provide, for instance, family law services to people who are incarcerated, and our housing program helps people who are accused of engaging in criminal activity or having criminal activity on their premises and are in jeopardy of losing their housing because of it. So just so you know, we have really stepped forward to try to be a primary source of information for the state so that we can spread this service out. Next slide. So let's talk about these other impacts that individuals who have had this touch with the criminal justice system face. There's this little technical term that you will be hearing and may have already heard that's called collateral consequences. So what are they? Next slide, Kirsten, sorry. So they are everywhere. A person who has had a touch with the criminal justice system is facing barriers in employment, which we're going to cover in the next few slides, and housing. You may or may not know that even having a criminal record could affect parental rights. In Illinois, a person who has 3 felony convictions could be considered, in our law, the term is called depraved. And if they are found to be depraved, then they may be in jeopardy of losing their parental rights. We see consequences following people who've sometimes long paid their dues, long served their sentence, but are suffering these collateral consequences in voting and jury service, um, education. Colleges and universities do background checks. There are certain types of offenses that would disqualify people from getting public benefits. They may be able to get food stamps or SNAP, but they may not be able to get monetary benefits because of certain types of convictions. And while I won't get into a lot of detail about immigration, I do want to say here that anyone who is not currently a citizen, um, getting criminal records relief is not recommended until the person has consulted with an immigration attorney, because the immigration process does require disclosure of all arrests. And if the record has been removed from public view, that information is not accessible anymore, not even by the person who was arrested. So we don't recommend that anyone who is not a citizen proceed with any criminal records relief without advice of an immigration attorney. And the last collateral consequence to talk about is that of what we're calling criminal debt. When a person is convicted, not only are they sentenced to serve time in supervision or even incarceration, but they may also be fined. And there are all types of costs that are also levied against the person. Court costs and costs of certain programs are supposed to be funded by the fines that are levied against them. And often they're not able to work off those debts while they are incarcerated. So when they exit, they still have that mound of debt. Now, before we go into some of the details, we wanted to stop and maybe check to see what your level of understanding of these collateral consequences were. So, Kirsten is going to administer a quick poll of about 5 questions. So, let's just see what you know about these collateral consequences.
Okay, I just launched the first poll and it reads, if you have ever been convicted of a felony, you cannot vote in the state of Illinois. So if you could just answer this to the best of your ability, we'll give everyone about 30 seconds to answer it. Okay, I'm going to go ahead and close the poll and share the result.
All right.
So it looks like about 42% think that it's true, 47% false, and 11% maybe.
Okay. How about that next question?
Okay. So the next poll reads, if you have a felony conviction, you can never live in public housing. We'll give everyone another 30 seconds. Okay, I'm going to go ahead and close the poll and share the results.
Okay, thank you.
And then we'll do the next poll, which reads, private landlords have no restrictions on the types of criminal backgrounds used in decisions to rent. Again, we'll give everyone about 30 seconds. Okay, I'm going to go ahead and close that poll and share the results. We have 2 more. So here's the results for that, Cynthia.
Okay, thank you. I have them.
And then the next poll is a person must consent to a background check and be provided a copy if they are denied employment because of it. Okay, I'm going to go ahead and close that one and share the results. So there's those results for you, Cynthia.
Have them. Thank you.
And last one, the same record prohibitions in housing applied to employment too. Okay, we'll go ahead and close that poll and share results.
Okay.
There's that for you, Cynthia.
All right. Thank you, Kirsten.
Okay, we'll go ahead.
All right, so let's get back to the presentation and let's learn a little bit about this. So let's start with these voting rights. So the answers were 42% of you thought it was true that if you've ever been convicted of a felony, you can't vote in Illinois, and 47% said that is false. 11% said maybe. And the answer is really maybe, because if you are currently serving a sentence, you can't vote in Illinois. But once the person is out of incarceration for serving a sentence, whether that's being on parole or mandatory supervised release, or if they're on probation, they can vote. So usually I say, if you're sitting across the table from me, you can vote. Those who said maybe are exactly right, and those who said false are mostly right. So thank you. So just know, if you are sitting across from a person, no matter what their record is, they are eligible to vote in Illinois because they are not serving their sentence inside a jail or prison. Next slide. Okay, let's talk about public housing, which is so important for people who have criminal records. There were 48% most felt it was false that if you have a felony conviction, you can never live in public housing. And that is mostly right, but the real answer is maybe, and 17% of you got that right. The real answer is maybe because there are 2 types of convictions that will absolutely bar a person from living in public housing or from getting subsidized housing. And that is if they are required to register on a sex offense registry as a result of a felony sex offense, then they are not allowed to live ever in public housing. The second one is a little more elusive and probably takes asking a few more questions. That is a conviction for manufacturing methamphetamine while in public housing or on federally subsidized housing. Now, again, that's a real tricky one because if the conviction occurred because of the manufacture of meth on a relative's property and that was not federally funded, then it doesn't apply. But that may be a little bit harder to challenge. But just know that that is the absolute law regarding denials of public housing. Only those two situations only. Next slide, Kirsten. You will probably encounter people who may have been denied housing or threatened with eviction because of alleged drug activity or a violent offense or something that, quote, threatens the health and safety of others. Well, those are all arguable in an administrative proceeding or in court. So if you have a client who those first two cases don't apply to, just know that if they're threatened with eviction or they've been denied public housing, there might be an opportunity to advocate for them and try to overcome those objections. For instance, what does violent mean? Is it having actually struck a person, or does the person have to have an injury? If they did get into just an argument where threats were shouted back and forth, that is called an assault. But was it a violent act? So those are the kinds of things that can be argued. All right, next slide. And now a word about cannabis. As it relates to public housing, this is a tricky one. What I've shown you here is an excerpt from a publication from the Chicago Housing Authority that came out shortly after the governor signed the Cannabis Tax Regulation and Tax Act into law. And CHA was putting their residents on notice that, hey, even though it's legal in Illinois, it's not legal in under federal law, and federal law trumps state law when it comes to housing matters. So they put out this notice, but they later amended that notice because they do have the ability to have local rules. And the Chicago Housing Authority decided to back off a bit on their rules after getting a little bit of pushback, I think, from the mayor and other elected officials. So now their new policy is that if someone is caught growing or possessing cannabis, then they will consider, quote, relevant facts on a case by case basis and mitigating circumstances. Now, since many of you are from other parts of the state outside of Chicago, you just need to check with your local housing authority regarding their rules because they do have discretion on whether they want to be this lenient or whether they want to stick with the, well, federal law rules here. And you'll be getting a copy of the slides, and I have provided the link so that you can see more about the CHA policy in that article. Next slide, Kirsten. Now, what about private housing? Prior to a new law that went into effect in January, private landlords could deny people housing for any reason that they wanted to. And there was no recourse at all in court to fight that. But effective January 1st, this is a statewide law that landlords now are required to get permission before they do a background check, and they can't consider an arrest that did not lead to a conviction. They cannot consider records that have been previously expunged or sealed, and they cannot consider juvenile records in deciding whether a person can get a house. So they are supposed to take application, and before they request a background check, they have to get in writing the permission from the prospective tenant before proceeding with the decision. And again, if the person was merely arrested, they cannot hold that against them. So next slide, Kirsten. So if your client gets a background check and it does show that one of those protected records is on there, an arrest that didn't lead to conviction, a juvenile case, or a case that was expunged or sealed, then go to the court and get a court disposition. And I think, Kirsten, if you click one more, you'll see a little box that says both of these can be obtained from the clerk's office. So get a court disposition if the case hasn't been expunged or sealed to show that it wasn't a conviction, or the client should have a copy of their order to expunge or seal. And once they present that to the landlord should retract the objection. Next slide. Now, there was a question that asked, the same record prohibitions in housing apply to employment too? And only 23% said that was true. So the majority of you didn't know this, but it is true. Those same rights exist from employment purposes too. Employers must ask for permission for a background check, and they cannot deny a person employment because of an arrest that did not result in a conviction. They can't look at expunged records, and they can't look at juvenile records. And in fact, the housing law was actually modeled after the employment law. So the employment law has been around for quite a while. Next slide, Kirsten. So if you do encounter a client who's been denied housing or who's been denied a job, and it appears that it was based on a record that the employer or the landlord should not have considered, here's where you go in Illinois. It is the Department of Human Rights, because this is the Illinois Human Rights Act that provides this coverage. And we've given you the number here for their office here in Chicago, where you can call to start that process. Note that there is a time limit. You have only 300 days, almost a year, but short of a year, to file the complaint. So the sooner the better to get on it. Okay, next. Now you may have also heard about ban the box from the perspective of employment. Illinois does have a ban the box law. And what that means is that employers, some employers, most employers, can't ask the question, have you ever been convicted, on the application itself. So that question is banned from applications in Illinois, but it's only under certain situations. And on the next slide, you'll see where those rules apply. It only applies to employers that have hired 15 or more employees. Now that's statewide, that is the state law. So think about mom and pop shop where they only have 10 employees. This law does not apply. So they can ask the question on their application, except in Chicago. Chicago has an ordinance that this rule applies to every employer that operates in the city of Chicago. Now, this rule also doesn't apply to any employers that are governed by state or federal law that prescribe certain types of convictions that would prohibit the person from working in that federal or state governed position. And on the next slide, we have some examples in Illinois of some of those state laws. Park districts. in healthcare, and that's every position in healthcare, LPNs, CNAs, doctors, um, pulmonary specialists, anyone that works in healthcare, school systems. The key here is that these are positions where the person would have to be fingerprinted in order to go through the employment application. So that's the key. If the employer is required to get a fingerprint background check on their employees, on their prospective employees, then they can ask the question on their application. Okay. So FedEx cannot, but CTA, Metra, any transportation, metropolitan transportation company can, because they are governed by law in this way. Okay. All right. Next. So if you see an application and it's not a mom and pop shop, except in Chicago, and they're not governed by law, you know that they don't require fingerprints, and you see that question on the application, it is a violation of state law. And you have recourse. You can, again, file a complaint, register that complaint. Statewide, you can go to the Illinois Department of Labor, and in Chicago, there's also the Chicago Commission on Human Rights that governs their ordinance here in the city. All right, next slide. Also related to employment, just as we said, landlords have to get permission to conduct a background check, so do employers. That is not just the state law, it is also a federal law for employers. It falls under the Fair Credit Reporting Act. Now, you might say, what does credit have to do with a criminal background check? Well, they are both considered consumer reports under the Federal Fair Credit Reporting Act, and it governs all consumer reports. For employment purposes, the federal law says the employer has to get permission, and also if they are using the information from that background check to decide whether or not to hire the person because of the nature of the conviction on the record, then they must give the individual a copy of that background check without the person asking for it. They must give it to them in advance of making that decision, and they must give them a reasonable amount of time to respond, because there are errors. And sometimes expunged and sealed records show up on a report that shouldn't be there. Or sometimes mistakes are made with common names. Background checks that are done by commercial background check companies are not necessarily always accurate, especially for people with common names. So encourage your clients to get those background checks if the employer does suggest that that was the reason that they're not hiring them. Know that they have a time period to respond. And if they don't get that background check report, the employer has violated the Fair Credit Reporting Act, and there are remedies available to the individual. So they should seek out an employment lawyer to perhaps file a complaint against that employer under the Fair Credit Reporting Act, under the federal law. There are monetary judgments that can result from that as well. All right, so that pretty much completes our discussion about those collateral consequences, all of the challenges and barriers that people face because they may have a criminal record at some point in their past. Now that you have a bit of an understanding about all of these barriers, we're going to talk a little bit about how to get rid of those barriers. So in the next few slides, we're going to talk about what is a criminal record, and I'm going to explain the various types of relief that are available. And we'll conclude by telling you where you can help your clients by getting them to the right people who can help them. So next slide, Kirsten. So first of all, what is a criminal record? Well, I think it's important for you to understand how they get created. The first way that a record can get created is if a person is arrested, and that is pretty standard. We know that if a person gets handcuffed and they get booked, they probably have a record. But I want you to understand where that record goes. There are three places where that record is initially stored. As soon as an arrest happens, as soon as the person is fingerprinted, there is a record of it at the city or the village police department that arrested them. They are required to notify the Illinois State Police, and the Illinois State Police notifies the FBI. So right away, there are three different databases that contain a record of that arrest. And that record exists even if the person is released without being charged. That's what that RWOC box is there on the right. They could be released without being charged, but there is still a record of that arrest that could show up on a background check report, that could show up, especially if the person is fingerprinted. Okay, so three locations right off the bat. Now, if that case is that arrest results in a court case, now there's a fourth database where a record is maintained, and that is in the circuit court. The circuit court is then required to report back to the Illinois State Police once the case is resolved. So they send the final disposition information to the Illinois State Police. And of course, it's recorded in the circuit court. So when we are talking about a person's record, just know that it can be in a minimum of 3, probably 4 different databases that we'll have to try to address through this process. Now, that's not the only way. An arrest is not the only way that a person could get a criminal record. A criminal record could be created if a complaint is filed against an individual, whether or not that person is arrested. And an example would be if, for instance, the person wrote a bad check at Walmart. Walmart doesn't find out that the check is bad right away. Once they do, they can file a complaint against the individual for writing that bad check. They've got the person's name, they've got the person's address, that a person will receive a summons to appear in court, and they're going to be charged with deceptive practices. That is a criminal offense. It would start in circuit court. The circuit court, remember, is required to send dispositions to the Illinois State Police. The Illinois State Police is required to notify the FBI. So again, if the record starts with a complaint having been filed, it will reside in the circuit court, the Illinois State Police, and the FBI. So again, a minimum of 3 databases. Okay, that's how pervasive criminal records are. So now, once you have a record, next slide, we'll talk about what happens once we get that record. So there are really only 2 outcomes. Either it's going to be a non-conviction or it's going to be a conviction. And a non-conviction, there are 2 types. In that previous slide where we showed that, well, a person could be arrested and then they could be released without being charged. Well, that RWOC is obviously not a conviction. But if the case makes it to court and the case is dismissed somehow, or if the person goes to trial and they're found not guilty, obviously those are not convictions. But what you may not know is that there are some types of sentences that a person could get after they are found guilty that could still result in a non-conviction here in Illinois. And I'll tell you about those in a moment. The other outcome, obviously, is a conviction. So we will explore what is a non-conviction and what is a conviction and those types. Next slide will show another factor that we have to consider when we're looking at criminal records. You also need to know whether the person had a misdemeanor offense or a felony offense. And they are distinguished by the nature of the sentence that the law prescribes. So a misdemeanor, the law says this offense could be punishable by up to a year in jail. That's up to 365 days. A felony is punishable by a year or more in prison. So that would be 365 days or more. That's really the distinction between misdemeanor and felony. Within misdemeanors, there are three types, Class A, Class B, and Class C. Class C is also called a petty offense, and it's not necessarily criminal in nature. It's not considered one of those types of offenses that is eligible for any other type of relief because it's just not considered a criminal offense. But Class A and B are, and we also have some city ordinances that are criminal in nature. Not all city ordinances are. You know, it's not a crime not to cut your grass, but you could still be in violation of the city ordinance. But it is in some cities a violation, a criminal act to drink alcohol on the public way. So those are unique to a local city or village. But if they are criminal in nature, they are misdemeanors. On the felony side, felonies fall under 6 different classes. The most serious of which is called murder, Class M for murder, and then the seriousness declines as we go down this list. The next highest severity is Class X, and then a 1, and then 2, and 3, and 4. So the higher the number, the lower the severity of the felony. And this distinction is based on the number of years that the person could be sentenced to. There's a range of years associated with each one of those classes. For Class 4, for instance, the lowest one, it's no more than 3 years. 1 to 3 years would be the max sentence for a Class 4 type felony. All right, so you've got non-conviction and conviction in your head. You've got misdemeanor and felony in your head. So now let's talk about eligibility to get rid of these records on this next slide. Understand that it's really as simple as this. If you got a non-conviction, it's going to be potentially eligible to expunge. If you have a conviction, it may be eligible to seal. Those are the only 2 options that are available for us, expungement or sealing. They are 2 separate remedies. In both cases, they result in the cases being removed from the public view. But on the next slide, we're going to see what is really the difference between these 2. It's who can see the record after it's been removed from public view. For a record that has been expunged, no public or private entity can see it. No landlord, no employer, public or private, fingerprinting, employer or not, they can't see a record that has been expunged. Even the police cannot see a record that has been expunged because for the most part, the record is destroyed. There are some exceptions that you'll see in a moment that the police can see. But other than that, non-convictions that get expunged are no longer accessible by police. A sealed record, no public or private entity can see sealed misdemeanors. Again, even if they are a fingerprinting type agency, if a person seals a misdemeanor, it's not going to show up. Sealed felony convictions, however, are still accessible by those special employers that are allowed to do fingerprint-based background checks. So remember from that previous slide, I gave you some examples of some of the agencies in the state that are governed by law that do fingerprint-based background checks. Those employers would be able to see a sealed record, a sealed felony record, park districts, schools, healthcare, the Metropolitan Transit Authorities. They would be allowed to see a sealed felony. Law enforcement can also see all sealed records. So if a person has sealed their record and they are stopped for a traffic stop and the cop runs their name, if they've had their record sealed, yes, the officer will be able to see that this person had records and that they were sealed. So that's the difference between expungement and sealing. Most people are concerned more about the employers and not about worrying about getting a traffic stop. So being able to remove these records from public view and restricting access for employers and landlords and others is really the key. Next slide, we're going to get into a deeper understanding about these types of sentences. So remember, our two options are expunging or sealing. We expunge non-convictions, we seal convictions. So what are these? So here's on the left is a list of the non-convictions. I'll go over them again briefly. Dismissals, case thrown out of court, found not guilty, or released without charge. But notice below that, there's a sentence of supervision or a sentence of a special probation called 17 and 1410, or a sentence of task probation or second chance probation. Those are called qualified probations. Those are those special sentences that a person is found guilty, but when the judge sentences them to supervision or one of these special probations, if they follow the terms of those supervisions and complete them satisfactorily, they won't have a conviction. These are usually reserved for one time only, first time offense, and one time only. Then there's a special program called an offender initiative program, and this is where it doesn't even result in a finding of guilty. It's more of a diversionary type program where the person is given a specific task to perform, like community service, maybe even paying restitution. Once that is completed, then the state agrees to drop the charges. So it's like a dismissal. So those are all eligible to be considered for expungement. What is a conviction, though? Well, if the person is sentenced to jail or prison, if they have a probation that is not one of those special probations, that is a conviction. So the key is whether there's a special qualifier in front of that word probation. If it is, it could be a non-conviction. But if it just says probation, plain vanilla probation is what I call it, it is a conviction. Also, there's a sentence that you may hear about or see on a person's record called conditional discharge. That is a conviction. If the person was sentenced to, was arrested, and then by the time they got to court, let's say they spent the weekend because they got arrested Friday night, they saw the judge Monday morning. When they see the judge, things happen very quickly in court. The next thing they might have heard was time served. And the judge might even say you're dismissed. Well, it's not a dismissal. Time served means that I would have found you guilty and sentenced you to 2 days in jail. You've already spent 2 days in jail, so you've served your time. That is a conviction. And then those city ordinances and village ordinances that I told you about, that if they are criminal in nature, they may not result in an arrest, but the person has to come to court if they are found guilty and they are fined, even a minimal fine of, let's say, $25. That is a conviction. Okay, so this is your list of convictions and list of non-convictions. Now, with that, you are now ready to understand how we determine who's eligible. So next couple of slides. The next one is just a little title page, I think, Kirsten. So we could skip over that one. Oops, it's not advancing that I can see. Can you hear me, Kirsten? Am I frozen? I am not certain if you can hear me. My screen seems to be frozen.
Cynthia?
Okay, oops.
Cynthia?
Hold on, I'm trying. I dialed in, so now I got to hang up. Oh.
We apologize for the technical difficulties, everyone. Give us a couple seconds and we'll get it figured out.
I think I'm back. Can you hear me now, Kirsten?
Yes, I can.
Okay, I just went completely frozen and I didn't and the screen wasn't advancing. I'm sorry. And then I tried to call in and got echo all over the place. So sorry about that.
I think it was on my end. Actually, my internet connection went away for some reason, and then I couldn't hear you to tell me to advance the
Okay.
slide. So
Okay.
minor setback, but we worked through it. So
All right.
is this the correct slide, or do I need to go back?
No, I think if everybody heard what I said about expungement and sealing, I think we can go on. Thank you.
Okay.
Okay, so just picking up, this is a list of some of the most common acquittals or dismissals that you'll see. Again, I've talked about released without charging, but you may see finding of not guilty. That means they went to court and got acquitted. Noli prosequi is a Latin term that means not prosecuted. Stricken off with leave to reinstate, or SOL is it is abbreviated. You'll see those. You'll see non-suit for city ordinance and village ordinance violations. That means they were dismissed. Finding of no probable cause is when a person is charged with a felony offense and they have what is called a preliminary hearing before a judge. If that judge does not feel that evidence supports taking that case forward, they will be found not guilty, finding of no probable cause. And then there's some older ways that cases are dismissed that we don't see a lot anymore, but they may show up on a person's rap sheet from many, many years ago, and it's called dismissed with prejudice, DWP, and leave to file denied. So those are some examples of ways that a case could get dismissed. So now if we can advance to the next slide, is just a title slide, I believe. Yeah. So now that you've got in your head about convictions and non-convictions and misdemeanors and felonies and what kinds of dispositions are non-convictions, let's now talk about what's eligible to expunge and seal. So next slide, we'll start with expungement. And remember, expungement is for those non-convictions. There could be some special sentences called supervision, where the person is found guilty and it's not a conviction. Those are generally eligible to expunge. There's only these exceptions. There are 3: DUI, reckless driving, and a sex offense that involved a minor. If a person receives supervision for those and satisfactorily completed it, it's not a conviction, but the law does not allow those to be removed from public view. There is an exception for reckless driving, and that is what is called the youthful offender exception. If the reckless driving charge occurred prior to the person reaching the age of 25, they can apply for it to be expunged. But if they were 26 when it happened, no luck. It is not going to be eligible to be expunged, even though it's not a conviction. Next slide. Remember that convictions, that's serving time in jail or prison, probation, conditional discharge, a fine, those are all convictions. All convictions are eligible to be sealed in the state of Illinois unless they are one of these 4 categories: domestic battery and violations of orders of protection, or stalking no contact orders, a conviction for the violation of the Humane Care for Animals Act, that's dog fighting or cruelty to animals. The next is a sex offense under Article 11 of the statutes, of the criminal statutes, except for prostitution and misdemeanor public indecency. Those are the only exceptions under a sex crime. And then DUI again. And we also have that reckless driving and the youthful offender exception. So those are the only types of convictions that are not eligible to seal. You might ask, well, what about murder? Well, murder is eligible to seal. It's not one of these 4. Okay. Now, being eligible doesn't necessarily mean it's going to be sealed, and we're going to talk about that later, like what kinds of factors need to be considered. The next slide will also explain a few more provisions that we have to look at beyond eligibility. So once we know whether we have a conviction or a non-conviction, whether it's eligible to expunge or seal, we also have to determine can we proceed now? Because there are waiting periods built into the law. For most acquittals and dismissals that are eligible to expunge, there's no waiting period. There is an exception for that special stricken off the docket with leave to reinstate or SOL and non-suit. There is a wait of 160 days before those can be expunged. And that's just because the state can bring the charges back within that period of time. So you have to wait until that amount of time has passed before we can try to remove it from public view. We talked about supervisions. Again, if they are satisfactorily completed, they are eligible for expungement, but we have to wait 2 years from the date the person completed their sentence. And remember those special probations that I talked about that had some qualifier in front of the word probation, like 710, 1410, second chance, task? Those special probations, not convictions if all the terms are satisfied, but we have to wait 5 years before they can be expunged. Now, those convictions, we have to wait 3 years. And the wait period for sealing is calculated a little bit differently than expungement. For sealing, we have to wait 3 years from the date that the last sentence the person served was completed. And that waiting period applies to every conviction on the person's record. For example, if they had a 15-year-old conviction for, let's just say retail theft, misdemeanor retail theft happened when they were teenagers. Well, if they recently were ticketed for DUI and they received a supervision for DUI, and it's not a conviction because they satisfactorily completed, still, the last sentence they served, we've got to count 3 years from that in order to seal that now decades old retail theft from the time that they were 18. Okay, so that's the heartbreaking part of these waiting periods, is that some recent issue may put a person in a waiting period for 3 years. But there is a little bit of hope. Next slide, Kirsten. So there are some exceptions. If a person is charged with an offense and the attorney is able to get that charge dismissed, they can immediately apply to have that case sealed. It's a dismissal, which means that it's not a conviction. Ultimately, it would be eligible to expunge. Remember, expunged record is completely destroyed, where a sealed record is still accessible by law enforcement. Well, the law does say, well, yeah, you could get it expunged, but we're gonna give you the option if the judge if the defense attorney submits the petition, the state is here, they can object if they would like, but the judge does have the discretion. If presented with the question, they could seal that record immediately. So that's one way to avoid a waiting period. Next slide is another way to avoid a waiting period. So if a person is currently on probation or on parole, if they obtain an educational certificate or a workforce development certificate, a job skills certification while they are serving their sentence, this must be obtained before they are off probation, before their probation is terminated. before they are discharged from parole. If they complete this educational requirement during that period, then they can waive the waiting period. They can file a petition immediately. So many of the people that you are working with could very well be in this situation, and by your helping them to get certified, you will be able to avoid a 3-year wait for them to move forward and get their record cleared. All right, next slide. Now, you need to know that there are certain types of convictions that would require the person to attach a clean drug test to the petition at the time of filing. And that's if they are petitioning to expunge under one of those special probations, and it is a drug-related felony sentence. Then they would need to attach a drug test to their petition at the time of filing. If they are trying to seal a drug-related felony offense, then they will also need to attach a drug test to the sealing petition. Now, they only need to take one drug test, make copies of it if they are filing a petition to expunge some records and filing a petition to seal others. Only one drug test. Now, we're going to talk about the cannabis law in a little bit as well. And now that cannabis is legal, the possession and use of it, recreational use, is legal in the state of Illinois. We are not sure how some judges will react if a person does test positive for cannabis, because that is one of the drugs that is tested in the basic drug test. It remains to be seen what will happen, because you'll see when I talk about what happens in court is that the judges have discretion in whether to grant a petition or not. So we'll just have to see how that works out. Obviously, it can be argued that, just like alcohol is now legal to, it's legal to drink, but we don't have a test that they are required to present at petitions for having consumed alcohol, but we do have a test that would test for the consumption of cannabis. All right, so just be aware of that, and you might want to alert your clients to that. All right, so next, since I'm talking about cannabis, let's talk about cannabis. So here's this Cannabis Regulation and Tax Act. It was signed into law about a year ago. I think it was June 25th when the governor signed the bill into law. There's a term that you should be familiar with, and it's called the minor cannabis offense. So next slide, let me tell you what that is. This is what this act applies to. It is legal in Illinois to possess cannabis, but not a lot of it. It's got to be 30 grams or less. So to give you an idea of what the heck is 30 grams of cannabis look like, I found on the internet some pictures that may give you a clue about how much we're talking about. So there's some examples of some cigarette type rolls up there that is the equivalent of one. So they could have 30 of those, or they could have this picture that shows the handful. That's about 30 grams or less. So if it's 30 grams or less, for possession of cannabis, that falls under the cannabis statute in what they call Section 4 of the law. Section 5 of the law describes the manufacture or delivery. So minor cannabis has to be one of these two sections, not any of the other sections. There are, for instance, a special section for possessing or even delivering on school grounds. Well, that doesn't apply under this law. That's not considered minor cannabis. Only possession or manufacture or delivery with intent to deliver if it was 30 grams or less. And it can't have been a charge against someone who was at least 18, who tried to sell to somebody who was under 18 and 3 years this person's junior. We know that because they're going to get a sentence enhancement if that was the case, and those do not qualify. Also, if the person was charged and convicted simultaneously of having a violent crime, even if it was dismissed, it doesn't even have to be a conviction. For instance, if the person was charged with domestic battery and possession of cannabis, it does not qualify, even if the possession was 30 grams or less. So these are the 5 things to think about in terms of whether or not the Cannabis Act applies to it. Next slide. So now understanding what minor cannabis is, if it's a non-conviction, it is eligible for automatic expungement by the Illinois State Police and the arresting agency, the city or village that arrested the person. Those automatic expungements are, nobody has to take any action on those. They will take care of them automatically. The first deadline for that is December 31st of this year for any arrests that occurred within the last 7 years. And then there's a schedule for automatic expungement of older non-convictions. That shouldn't be an issue because if it's a non-conviction and it's more than 7 years old, it's not supposed to be reported on background checks anyway. So that was the reason for the phased approach. Now, if it was a conviction for minor cannabis, 30 grams or less, possession or manufactured delivery of 30 grams or less, then it is also eligible to be automatically pardoned by the governor. The Prisoner Review Board will submit to the governor this petition to have that conviction pardoned. And again, no action would be needed on the part of the individual for this to happen. However, we don't know whether the Prisoner Review Board is going to exercise any discretion in who they submit to the governor for the automatic pardon. They have that option. So thankfully, there's a third option, and that is any cannabis case that is 30 grams or less, if it's not taken care of by pardon, and also if it's a manufactured delivery possession of even more than 30 grams up to 500 grams, that's an exception. There is another option called the motion to vacate and expunge, and that can be filed on behalf of the individual or by the individual, or even by state's attorneys. In Cook County, and I think I heard DuPage County, maybe Will County, and maybe Winnebago County the state's attorneys were planning to automatically file these motions to vacate as well. So if they do, then there will be no action required on the part of the individual. But that is an option that is available as well. Okay, I just filled your heads with a lot of information. And as we begin to wrap up, let's just take another quick poll to see how much we may have learned as a form of review. So if Kirsten will administer the poll, we've got a few more questions, 5 more questions, and then we'll wrap up.
Okay, I just did the first one. It says, in all circumstances, if a person pleads guilty or is found guilty in a case, that case is a conviction. So we'll give everyone about 30 seconds again. Okay, go ahead and close that and share the results. So here are the answers for you.
Sophia. Got them.
The next poll is about to launch. It's loading. Employers can ask on job applications, have you ever been convicted? Okay.
Okay, got it.
The next poll, loading, asks arrests that do not result in convictions will not appear on a criminal background check. Okay, we're going to go ahead and close that.
Okay, I got it.
The next one is just about to launch. A conviction for dogfighting cannot be sealed. Okay, we'll go ahead and close that.
Okay, thank you.
And the last poll, all cannabis convictions are eligible to be expunged. Okay, we're going to go ahead and close that and share the results.
Okay. All right, thank you. So let's just go over the results real quick as a form of review. So the first question, in all circumstances, if a person pleads guilty or is found guilty, that case is a conviction. Maybe it was kind of a trick question. I'm sorry. You know, sometimes we lawyers do that. But 26% of you got it right. That is false. I said in all cases. You may not have caught that little nuance. Remember that we have special sentences that may not result in a conviction, even if there is a finding of guilty. Keep in mind those special probations and supervision. Satisfactorily completed, they are not convictions. Okay, and you're going to get a copy of the slides, so go to slides 27 and 31 to review that. The next question was, employers can ask on job applications, have you ever been convicted? Almost half of you got it right. That is a maybe, because some can ask. Remember, mom and pop shops outside of Chicago can ask. If they take fingerprints, they can ask on the application. So the answer is maybe. And that would be on slide 21 to refresh your memory. Also, the next question, this one, most people got this one right. Arrests that do not result in convictions will not appear on a criminal background check. That is false. Remember that diagram on page 26 about arrests? Even if they are released without charge, it's a record and it will show up. Next, oh, we got this one right. Dogfighting is a conviction. Is a conviction. And if it is a conviction, it can't be sealed. And 81% of you said true to that. That is correct. It cannot be sealed. Last question. Also, good showing on that. 76% of you got that right. All cannabis convictions are eligible to be expunged. That is false. Remember, it's only minor cannabis. That is section 4, which is possession and what we call dealing, right? Possession and dealing's got to be 30 grams or less. That's the only type that could be eligible, and it's got to go through these special processes to get expunged. Anything else, we'd have to go through that regular sealing process, perhaps, but not expunged. Okay. So I hope that helps. I hope that overview helps. And then these few little questions, because it's in the application of this information that you will begin to learn it. So when you get your copy of the presentation, I encourage you to just go back through, and you're going to see my contact information is on there as well. So you can follow up. If you have any questions, just send them to me. So now we'll just kind of wrap up, and now that you know about sealing and expungement, let's just talk quickly about procedures. Next slide. So all counties will assess a filing fee for petitions. This is the filing fee schedule in Cook County. It varies from county to county, the cost, but these are the kind of the things that they charge for. There's a base filing fee and a mailing fee, and sometimes they require dispositions. They do in Cook County. So to file a petition for one case is $157.50 in Cook County. Now, throughout the state, on the next slide, there is a law that applies statewide that allows fees to be waived. And the next slide, if you can, Kirsten. Yes, this is the schedule of the income levels, household income levels that qualify for a fee waiver. That is a separate proceeding that has to happen in court. So if a person is filing a petition and they meet these income guidelines, they can complete an application to have their fees waived. They will be sent to see a judge at court, and the judge may ask, if they're saying that they get LINK or SSI, they may have to demonstrate that. And if the judge grants the fee waiver application, then they don't have to pay any filing fees at all. So this chart just shows you the income levels, and that is a statewide. Those are statewide forms. Now, if the person either pays or they get their fees waived, the next step is to file the petition. And on the next slide, I've shown you the timeline that it takes for a petition to move through the system. So if we could see that next slide, Kirsten, on the filing process, there we go. Under the law, once a petition is filed, there is a mandatory 60-day period of notice. The petition has to be sent to the state's attorney's office, the Illinois State Police, the agency that arrested the person, and the chief prosecutor for the city or village where that person was arrested. All 4 of those entities receive notice that this person is trying to expunge or seal their record. And the law gives them 60 days from the date they receive that notice to file an objection in court if they choose to. Usually it's the state's attorney that will be filing those objections, even on behalf of the police department sometimes, but they can do it themselves as well. After the 60-day notice period, if there is an objection, then in most jurisdictions, that's when a hearing is absolutely scheduled. Some jurisdictions schedule hearings regardless. Right up front, they give a court date, like, here's your court date, be here on this date, and then you'll find out whether there are objections or not, or whether you have to have a hearing. If there are objections, then the judge will schedule a hearing on the matter. That timing depends on the jurisdiction and the size of their docket. Unfortunately, those of us who are in Cook County, there is a long backlog. It's been about 12 to 18 months, and that was before COVID. So it's going to be pretty tough here in Cook County. And in the other jurisdictions, you're going to see some delays as well, but not as severe, I hope. After the petition is granted, then it takes about 30 to 60 days for the arresting agency and the Illinois State Police to effect that order and remove the case from their system. The Illinois State Police will then notify the FBI, and that takes maybe another 6 weeks for the case to be totally removed. So this is not a quick process, and we want you to understand that it takes several months before a person can really see the relief. So they can't walk out of court and go apply for that job right away. They're going to have to wait. There are some confirmation letters that will come to let them know that the arresting agency has removed their case and that the court has removed theirs and the Illinois State Police has removed theirs. So they do get confirmation of everybody except the FBI. You just have to give them that extra 6 weeks or so. Okay, next slide. Now, if a person does need to, once the case is expunged or sealed, this is somewhat a repeat of what we talked about before, who has access to it after that has happened. What happens in the clerk system, if somebody does a search of the person's name, they'll see no record. That's what will come up, no record found. If it's expunged, except for those first time offense special probations that I told you about, those records are not destroyed, but all other expunged records are destroyed. And the reason that those special probations aren't destroyed is because, of course, it's the first time. You only get one shot at it, and they have to know that you had that one shot. So they can't destroy that, but the others are destroyed. And as I said, the sealed records are accessible at that point by law enforcement, and only sealed felonies are accessible by certain employers, those that do fingerprint-based background checks. Next. What happens in court? Sometimes a court will want the person to explain the nature of the conviction, like really what happened. They will consider that. They want to see proof of rehabilitation, and hopefully that it can be shown that it's related to the offense. For instance, if it's a drug-related offense, for people to show that they have gone through drug treatment programs and still be involved in AA or NA is always positive. Explaining about the conviction in the context of that person's life, like how old were they when it happened? What was going on in their life at that time? Maybe they were in the midst of a serious addiction when it happened, but they have been clean and sober now for a long time. Those are the kinds of explanations the judge wants to hear. What have they done in terms of education and employment? And it may be that the person, their inability to get a job is evidence that a judge would consider. If you have rejection letters to show that it's not for lack of trying that this person is still unemployed, but the barrier seems to be the criminal record. Also, sometimes employers will say, well, you know, I could hire you if you could get this sealed. That is always good to say to a judge. And any other specific reasons that the person needs that relief. Now, on the next slide, I just wanted to introduce you to a few what we call alternative forms of relief, because as we have talked about before, not all cases are eligible to seal. Not all convictions can be sealed. So sometimes you're left with something on the table. So Kirsten, if you'll advance to the next slide, I've just shown some forms of relief that you may be familiar with. You may have heard of, go to the next slide, is when the chart, there we go. Healthcare worker waivers are there for unlicensed positions in healthcare. A certificate of good conduct. This could help a person be employed by a school system, for instance, as a bus driver. A certificate of relief from disability is there for certain licensed occupations like barbering, cosmetology, nail technology. Morticians need this type of license. Marriage counselors and therapists, there are a lot of licensed positions that would qualify for a certificate of relief from disability. And then the ultimate relief is clemency from the governor for any type of conviction that cannot be sealed or expunged. You can always appeal to the governor for a pardon. And with that pardon, pardon could then be applied to a petition for relief. Okay, so that pretty much sums up all of the types of relief that's available, and I'll just close it out with an explanation about where to go to get help. Here in Cook County, next slide, you can see that there is a help desk for juvenile records at the Juvenile Temporary Detention Center at 1100 South Hamilton. They operate 5 days a week, all day, 9 to 5 or 9 to 4. So that's where juvenile records can be taken care of. Next slide, in Cook County, we have the help desks at the Daly Center and Markham. And by the way, we are not operating those desks right now. Of course, the court will be opening in July, and they will tell us when they are going to activate the help desks again, but they won't be physically activated until at some point in their planning under COVID. But in the meantime, on the next slide, and again, you will have this link once you get the package, we have created a virtual help desk. So if you go to CGLA's website, you can request expungement and sealing relief. You can fill out that form. They can upload their rap sheets, and we will be helping them with their petitions. And we've been doing that all through this COVID crisis, and we'll continue. It was a new thing that we created, but we're going to keep that going as well. Next slide. If you're not in Cook County, there is still help. On the northern part of the state is served by Prairie State Legal Services. We worked very closely with some of their offices, trained some of their attorneys. So I don't know that all of their offices are equipped, but you can go to Prairie State and they may be able to direct you to one of their offices where a person could get assistance. If not, you can just submit the request through our online help desk, and we can try to help you as well, because we can at least prepare the petitions even if we can't file them. And then the next slide shows you Land of Lincoln's contact information. That's the southern part of the state. And likewise, you know, we've partnered with them in Madison County and Champaign County and Vermilion County. So we're very familiar with Land of Lincoln. And if they are not able to help you, again, go to our website. The Prairie State and Land of Lincoln do operate with certain types of restrictions about income, they have very strict income eligibility guidelines, and they also are prohibited from assisting people that have certain conflicts. So if they can't help, you can always just submit to CGLA's online portal, and we can see if we can help. And that concludes the knowledge that I have tried to dump into your heads today. So you have my my contact information. I'm sorry that that slide shows it all covered up. So we'll make sure that it gets um, uncovered so you can see my my full email address and phone number. We'll make sure you get that. And I think it might have been on the first slide as well. So
Cynthia,
I
did
know
you
we're
want
past
to do,
times.
Cynthia, did you want to do a quick Q&A, or we
I
are
have
a
time.
little bit over on time. I would say we take about 4 minutes. We don't have that many questions.
Okay. Let me
So
see.
I have
Are
the
you
question for you.
okay? Okay.
So the first question is from Stacy. She wants to know, once a record is expunged, how long does it take from that record to be deleted from all 3 spaces that house those records?
Mm-hmm. So usually the court takes care of it right away because they've got the order. So you give them a couple of weeks, and then those will not be available. It takes the police departments about 2 months on the max, sometimes less than that, to remove it. But they have to get the order. So the court mails the order to the other parties. So we have to stay on top of the clerks in the office to make sure that they are mailed timely. And so from the moment that the judge grants a petition, it may take 2 months before it's completely gone.
Okay, great. Lynette wants to know, how does a RWOC get removed?
That would be a petition to expunge.
Okay.
Yeah, it is not a conviction, so we can expunge that.
Okay, Stacy would like to know, doesn't the seal and or expungement keep the records from being seen in a background check?
Yes, it does. Um, Most commercial background check companies, all commercial background check companies, cannot see a record that has been sealed or expunged. However, some of them maintain their own databases, and if they conduct their background from their own database, they may report it. That is against the law. The law does say that they are supposed to do a quote fresh research of a person's record when requested to do so. And if they do, they would go to the court, and the court would not show up in the court system. But sometimes if a sealed record is showing up on a background check report, either the court messed up because they didn't remove it, or they did remove it and it's the background check company that is in error. And again, in either one of those cases, that could result in some monetary damages. And there are attorneys that handle what they call FCRA, FCRA for the Fair Credit Reporting Act complaints against companies, background check companies that report sealed records.
Okay. Carmela would like to know, can you elaborate on senior citizens not being qualified for CHA senior buildings due to previous convictions?
Right. So remember that slide that said there are really only 2 types of convictions that are lifetime barriers, and that's if they are registered on the sex offense registry or if they were convicted of methamphetamine manufacture on on federal property. Those are the only 2. So if they have been denied because of past criminal convictions, you do need to see a lawyer. Again, Prairie State in the north, Land of Lincoln in the south, and Cabrini Green Legal Aid in Cook County, because they are not allowed to just unilaterally and in a blanket fashion, deny people because of past criminal convictions. That could be argued. Yeah. So, if
Okay.
some of them do have time restrictions, like in the last 3 years or something along those lines, but it can't be global and just no conviction at all. So I would say try to fight that,
Okay.
or get the record sealed if you can, and then they can't see it.
Okay, Stacy had another question, and I'm not sure if you can touch on this, but why is the wait so long for qualified probations?
That's a good question, Stacy. These are all, laws are always discretionary. And why the legislature felt like a person needed to wait longer to have the record expunged, I don't know. What we have advised people, though, is they can get that record sealed in 3 years if they would like to. Now, again, what's the difference? A sealed record is still accessible by law enforcement. But the end result, even the expunged record, is still accessible by law enforcement because it's that special probation. So, what we usually will do is advise the person to go ahead and seal it at 3 years, keep their paperwork, and then they can come back in 2 years and file to expunge it.
Okay. We had, it looks like one more question from Teresa. Does CGLA help with healthcare waivers in regards to criminal records?
Yes, we do. And I will say too, that sealing, if the record is sealed, the Department of Public Health ignores them. They can still see them, but they ignore them if they have been sealed. So if a person has a sealable offense, then they won't need a healthcare worker waiver if they can get it sealed first. But if not, like if they have domestic battery, that is a disqualifying offense, then yes, they would need a healthcare worker waiver, and we do assist with those.
Okay, great. Let me just make sure there's no other quick questions.
You are really breaking up on my end, Kirsten.
Questions coming in about people requesting the PowerPoint slides from this presentation. Those can be found in the handout section on your side panel. So you can access it. Hello, Cynthia?
Yeah, I can hear you now. You were really choppy there for a moment.
Cynthia?
Can you hear me?
Okay. Oh, sorry. Okay, I can. Yes.
Okay.
I just wanted to note that I just want to know that the video recording and the PowerPoint slides will be on our website as well as Illinois WorkNet website within 48 hours. We had a lot of questions about that. But
Okay.
with that being said, I think that is all the questions we have. Did you have any final words of wisdom, Cynthia?
Well, I hope this was helpful. I know it's a lot. It really does. You receive the same kind of information that we teach attorneys, and it just really takes walking through this quite a few times before it begins to sink. So I just encourage you to get your copy of the PowerPoint, read back through it. And if you have any questions, just email me. I will usually be able to respond to your email within about 24 hours.
Okay, great. And with that, thank you so much, Cynthia. A quick reminder that you will receive a follow-up survey tomorrow morning. So please provide us with any questions, comments, or concerns and feedback for future WEO webinars. And thank you so much to everyone who attended today and participated. Thank you, Cynthia, and everyone have a great rest of your Wednesday.
Okay, thank you.